All right, welcome everybody. Thank you for joining for our weekly webinar on the employment law essentials. Today, we're going to be talking about one of my favorite topics, which is workplace investigations, the when to do them, why to do them, and essentially how to do them. We will have a question and answer period at the end of our webinar. And a little bit about ourselves. We are Achkar Law. We are one of the fastest growing firms here in Toronto. We were first founded back in 2016, and our focus has been on employment law, human rights law, labor law, civil litigations, and workplace investigations. We serve all of Ontario. We also serve out of province as well, with the intention of expanding out of province too. Today's presentation is going to be hosted by myself. My name is Charles Miller. I'm a senior associate here with Achkar Law, and I am joined by my friend Philip Petrovic, who is a partner here too. So, without further ado, what is a workplace investigation? And please forgive me if all of you already know what this is. I'm simply showing off that I know what it is too. Workplace investigation is a formal process to examine and review complaints or concerns related to workplace issues that are brought to your attention. Again, this is not a simple matter, as this is a bit different from an accommodation request. This is a formal investigation into matters brought to your attention. So, when should I start a workplace investigation? Well, good news is that 90% of the time that decision is made for you. Usually a complaint is brought across your desk either by a current employee or a former employee, raising concerns about something within the workplace that is compromising or problematic, such as fraud, theft, harassment. You as an employer have an active duty to ensure that you have a harassment-free workplace that is of the utmost integrity. So anytime someone raises a complaint, you must take it seriously and you must do an investigation. Yes, Phil.
Just to jump in and add to what Charles was saying, also, you may on occasion receive a complaint from an employee who you don't consider to be credible. Maybe it's a troublemaker who's caused problems in the past, and you may receive a complaint and you may think to yourself, well, this employee has a bad reputation. Perhaps I'm not going to investigate. They're probably just trying to cause a disturbance. Regardless of who makes a complaint or how credible you think they are, or whether or not they have a bad reputation, regardless of whether they've been in trouble before, and so forth and so forth, you should treat every complaint the same and don't make any assumptions. Even someone who has caused problems in the past in your workplace may still have a genuine complaint that they bring forward, and you should make sure you treat every complaint equally.
Thank you for that, Phil. Exactly as Phil said, take the burden off yourself. You don't need to make a snap judgment decision there. Be very unbiased, and when a complaint comes your way, look at the facts. All right. So the purpose of a workplace investigation is essentially to provide a clear and unbiased understanding of the situation. Just as Phil was saying, even if the complainant has a history, that's not for us to decide here. And in fact, even if they don't have a history, just because a complaint came across your desk doesn't mean it was legitimate. Sometimes employees will complain about workplace bullying and harassment when in fact all that occurred was an appropriate reprimand for work not completed. The purpose of the workplace investigation is to just determine that. What really happened? What are both sides of the story? Another purpose of your workplace investigation is to ensure compliance with all legislation as well as with your own company policies. Legislation for you to keep in mind are the Employment Standards Act, the Ontario Health and Safety Act, as well as the Ontario Human Rights Code, and any other policies you may have in place as well. As an employer, you have an active duty to ensure that your company and your workplace is compliant with all of that legislation. Another purpose of the workplace investigation are to ensure the right decisions are being made. Now, I want to put a caveat on this point here. Ensuring the right decisions are being made, ultimately, the employer, it will be your decision about what to do with the information that comes your way from the investigation. But having the investigation actually will help you make sure you make the right decisions. You'll often, with a workplace investigation report, get an idea and some recommendations of what to do. Avoiding any knee-jerk reaction. Again, use boring from what Phil was saying before about if you've got a problem employee who just likes to complain illegitimately. Well, this time they might actually have legitimate complaint, in which case you should respond. Making sure that you always make the right decision comes from having all the information necessary. Another important aspect of the workplace investigation is to ensure that you are conducting and monitoring a workplace that has the utmost integrity. There is a lot of responsibility as an employer that Ontario laws and Ontario courts expects you to maintain. Certainly, you've heard that if anything goes before a trial judge, the courts tend to favor the employee. That's an unfair reality, which means that you're held to a higher standard. So maintaining a workplace of the utmost integrity is essential to you. Also, by doing so, you can make sure for your own well-being that all of your employees and your managers working under you are following the policies, following the legislation, and you can be proud of the workplace you have. Furthermore, by having a workplace investigation, let's imagine you're actually in an active claim right now. A former employee has issued a claim against you. And often when you're in a litigation position, you might have a him, like us versus them mentality, very antagonistic sometimes in litigation, with the employer often being perceived as the villain and the employee being perceived as the poor, unfortunate soul. Well, if you've done a workplace investigation into these complaints that come across your desk, you change that narrative. It stops being a villain employer versus the poor employee. Essentially, you can go to the judge, trial, or jury and put the facts before them and say, hey, listen, Your Honor, we had this complaint come across our desk. We investigated it. These were the facts and reports we came before us, and this was the decision we made, and leave it for them. It takes the focus off of an us versus them mentality and turns it more into a let's just look at the facts. This is an unbiased approach. You acted with utmost integrity, and the courts and judges love to see it. Another purpose of a workplace investigations are to mitigate issues. This comes down to if at the end of the report you confirm that some compliance wasn't maintained, or perhaps there's some legitimacy to the complaint, you can now, as the employer, decide what's your best course of action. How should you respond to this? Maybe it's time to put some new policies in place, or maybe it's important to focus on just a resolution. So, what should I do to prepare for a workplace investigation? Now, if you've attended these webinars before, you've probably heard Philip and I say that the best thing an employer can do is prepare, prepare, prepare. The best offense is a very good defense, and 90% of your footwork should be started before a claim or a complaint ever crosses your desk. So having policies in place ahead of time for how to conduct a workplace investigation is important. Having policies in place for who to go to talk to, as well as having a step-by-step template is excellent so that you know what to do. You know how to gather the evidence, gather what documents you need to look into, what emails should you be following, are there any recordings you need to go through? You might also look at identifying potential witnesses. Often when a complainant comes to your desk, they'll complain about, let's say, workplace harassment, a manager being too much of a bully. Well, get those emails, look at any text messages, review it critically. Did this occur? Did anyone witness this? Go into the facts and just gather all the evidence and start to review it. Ideally, as well, you may consider hiring a third-party investigator. I've often said that with workplace investigations, it is all right to have an internal investigation policy. Doesn't necessarily mean your company is making a biased investigation. It comes down to credibility. But rather than go through that test of whether or not your investigation was credible, it would be ideal to hire a professional who is not only independent, third party, but also knows the steps, knows the questions to ask, and knows what sorts of suggestions and next steps you should take once they finish with the report. Phil, take it from here in terms of selecting the right third-party investigator.
Thank you, Charlie. So a couple of things, everyone. When it comes to selecting a investigator, For your information, theoretically, as Charlie mentioned already, you don't absolutely have to hire a third-party investigator. The reason why you would do so is because you want to ensure that your investigation appears as unbiased as possible. Otherwise, it is possible to investigate on your own. And in fact, many employees, for example, human resources people and other sort of roles, they undergo training for that. And law firms and other businesses even provide human rights training. In fact, we do. We provide investigations training. That's one of the things we do. So theoretically, you don't actually have to hire a third-party investigator, but typically companies will do it because they don't want to have to worry about whether the investigation is credible, whether they crossed all their T's and dotted their I's, so to speak. They just want to have it dealt with by someone else. Typically, when you are looking into hiring an investigator, you'll want someone who has proper experience. The reason why that's relevant is because it is possible to, make a mistake while investigating. It is possible to botch an investigation. The standard is not necessarily perfection. You don't have to investigate perfectly, but there still are some things that you need to cover. For example, one mistake my colleagues and I have seen happen. So imagine this. You have an employer who receives allegations about an employee. They perform an investigation. They fire the employee for cause. The employee then sues them for wrongful dismissal. Why does the employee sue for wrongful dismissal? Because when they investigated, they forgot to question the very employee that was the subject of the allegation. That happens. One would think that it's normal to actually interview the subject of the investigation and to explain why they're being investigated and so forth. But, mistakes happen. And again, even though the standard is not perfection, you still have to cover certain bases. And that's why it's important to, in most cases, just have a third party do it. You always want someone who's neutral. So the benefit of a third party investigator is that this person has no connection to the company or the employee. They don't know the business. They don't know their inner workings of the company. They're coming in with a clean slate and fresh eyes. And that's relevant to you because it's more likely that they will be neutral. They'll investigate neutrally. They'll question everyone. They won't have any clear bias. And their job will be to get the facts. Because bear in mind, everyone, an investigator's job is to do fact finding and to determine what is more likely to have occurred than not. It's not to make any presumptions of guilt or innocence or so forth. It's to find out what probably happened. So you want someone who's neutral. You want someone who has a proper approach and methodology. And by that, we mean, for example, you want someone who understands that questioning all the witnesses, including the subject of the complaint, is very relevant. You can't skip any of the steps. And you want someone who knows that and knows what they're doing. You want someone who has a proper reputation for being an investigator. Typically, you will find companies, more often than not, they're law firms who offer workplace investigations. For example, our firm offers that. That's one of the things we do to help employers. Availability and resources. This is important because investigations can take a long time sometimes. It really depends on how many witnesses there are, how many facts are the subject of the complaint. Did the complaint span months, years? Are there many issues to sort of go into? All of these things will determine whether a complaint takes longer to investigate or shorter. So ultimately, the scheduling can be demanding. And it's not only the scheduling of the investigator, but also of the witnesses. There's a lot of organization that goes into it and a lot of back and forth that goes into outlining all the steps, getting everything scheduled, making sure everything is covered, and sort of going step by step until you've actually reached a conclusion. So availability and resources, very important. Communication is also key. You want someone who asks the right questions, communicates things clearly, and doesn't skip any steps. Those things are very important. And the reason why they're important, again, it all goes back to you don't want to have a botched investigation. A botched investigation can open up the company to liability that may not have existed had the investigation been done more properly. Now, of course, this standard becomes even trickier if it's the employer that's investigating. So that's why it's helpful to have a third party do it. So what are the steps? You get a report from someone, there's an assessment of what happened, when did it happen. You find an investigator, they plan everything and they do it independently. So typically, a third party investigator will operate on their own. They will certainly contact the employer, they'll contact the employees, but they will sort of work on their own. And that's normal because again, they're hired to perform one task, and that task is to investigate. So they'll operate their own way and the way they see fit. While operating, they will gather evidence. That can be in the form of documents, text messages, audio recordings, video recordings, statements from witnesses. They will speak to witnesses and they'll schedule all of that. They may have discussions with the subject of the complaint. They may have discussions with the employer. Either way, there is a process to it. And just like any case, you always want to make sure you have all the evidence before you make any conclusions or jump the gun and decide what happened, what didn't happen, so forth. Because again, the implications of a correct or incorrect decision can be important for the employer. So it's all very crucial. It's just generally speaking, it's crucial that all the steps get followed. Once they have all the evidence, they're going to look at it and say, okay, what does the evidence tell me? What is more likely to have happened than not? Does the evidence prove something? Does it not prove something? Is there more evidence? Do I need to ask other things? These are all sort of considerations. And sometimes a case will have proper, good evidence. Sometimes there will be evidence that's missing. Unfortunately, there are situations where evidence is missing and nothing's ever perfect. That's just how it is. There's no way around it. But again, that's why you want a skilled investigator who knows what they're doing. Once the investigator does investigate, they will provide a report. Typically, they will provide the report to the employer, and the employer will then have to make a decision based on what is in the report. Typically, they will not provide the report to the employee. It's just for the employer, and then the employer is required to implement. However, they will tell the employee that the investigation is done. And when I say employee, I'm referring to the subject. So they will notify the employee that, hey, this investigation is over. At that point, the employer will have some decisions to make. The employer will then follow up with the employee and a decision will be implemented. That decision may be, oh, everything's good. No discipline, no dismissal, everything goes back to normal, in which case they'll tell the employee. Or there may be a finding of, for example, harassment in the workplace, in which case the employer may decide to dismiss the employee. A termination letter will follow and other documentation. So these are all sort of steps that will happen in any investigation. And again, it's very crucial to sort of complete an investigation step by step, giving thought and consideration to each step on its own, because it is a big deal, and you always want to avoid incurring liability where there's none to begin with. So at some point or another, you may be interviewed as part of an investigation. And interviews can seem scary. Certainly, I would understand that if someone said so. But at the same time, interviews are a regular and organic process and part of any investigation. And just like any question and answer session, you want to review the facts before you answer. You want to remain calm, answer professionally, ask questions where you don't know what's being asked. Don't make assumptions. Don't guess. Answer honestly. Don't speculate. And essentially answer the questions to the best of your ability. Accurate questions and, more importantly, accurate answers will lead to a more likely, better investigation. And a better investigation will reduce the employer's liability. So it's one of those things where when you are ever answering questions, the sort of basic blueprint to follow is answer truthfully, answer to the best of your ability, and make sure you understand what you are answering. One of the worst things you can do, just in general, is answer a question that you don't understand, sort of like signing a contract you don't understand. You just don't want to do it. It opens up more problems than before. So always make sure you know what you are answering. And if you don't know, you can ask. It's okay. It's normal. It's part of the interview process. Let's do the Q&A stuff first. So the question says, for a former employee that would like to submit a complaint of harassment in the workplace, is there a time limit? Well, there's no hard-coded time limit, but any complaint needs to be submitted as soon as humanly possible. The reason why, think of it this way. Imagine an incident happens and the employee doesn't report it for 2 years, for example. Now, in those 2 years, the employees involved moved to another company. One of them passed away. The evidence has been lost. Uh, you know, if the employee reports it so late, how can you investigate? You won't be able to draw a proper conclusion. Evidence will be missing. I mean, one of the problems, just in general, with some cases that are very witness dependent is what do you do if a witness dies, for example? These are sort of realities that we have to think about. I mean, it doesn't happen often or anything, but certainly it's something to think about. So that's why it's always important that if there is a complaint or an issue, it should be brought to the company's attention like immediately as it happens. There shouldn't be any delay. Delay can be harmful. So next question. What if the complaint wants to remain anonymous? Well, the thing with that, and that happens more often than not, because as you can imagine, there are two ways a complaint comes about. It's either a witness to a complaint and they're reporting it and they're scared. For example, they just don't want to be involved. They want to do their duty, but they don't want to be involved any more than that. That happens. Or you get someone who files a complaint and it's not anonymous, but they want to be anonymous. The issue is that for a proper investigation, at some point or another, the person making a complaint will need to answer questions. What you can do to alleviate that sort of fear and stress is make it very clear that anyone who does participate in an investigation will not be punished for it. They're not going to be punished for giving the quote unquote wrong answers. They're not going to be punished for saying the truth. They're not going to be punished for essentially explaining what happened. It's always a good idea to make that very clear that there will be no reprisal for participation in an investigation. That's one way to ensure that the employee is less fearful of reporting, because as you can imagine, it's stressful for an employee too. I mean, certainly for an employer as well. The stress goes both ways, and a lot of times people are scared and they don't know how to report or what to do, and that's why it's helpful to make it clear that there would be no punishment for it. For an employee claiming discrimination, what type of evidence would they require aside from their own statements? Well, evidence can take many forms. You can have text messages showing discrimination. For example, a text message from a coworker making some discriminatory comments. You can have an audio recording of the discrimination. You can have a video footage.
Yeah, just to build off of that. In terms of evidence you require, technically, you don't need any evidence beyond the actual complaint submission itself, because ultimately that could be everything, and it will come down to the credibility of the person bringing the complaint forward. But as Phil mentioned, there's a lot of other evidence that can go towards adding to the credibility of the witness in terms of telling the full story. It's not just their testimony alone. So the more evidence, written or witness evidence, the better.
In terms of timing, well, it's always best practice to investigate when you actually receive the complaint. It's not a good idea to wait too long. And the reason why is because just like it's bad when an employee waits too long to report the issue, it's similarly bad if the employer waits too long to look into it. And again, same reasons apply. What if a witness passes away? What if a witness moves on? What if the evidence is destroyed or lost in the process? So just with this is just general, but generally speaking, with any legal matter, the sort of rule of thumb and the philosophy that we follow as lawyers is when something comes up, you address it immediately or as soon as you humanly can, because waiting and delaying is almost never helpful. What if HR conducts an investigation and the employee rejects the findings and sues? Can this affect additional investigations? Well, so HR in that scenario may investigate and they may do a proper job, right? That's absolutely possible. They may do a thorough and reasonable investigation, and there may actually be no issues. However, what may happen is the employee may still say, "Oh, I don't agree. I don't care. I'm still going to sue." At that point, the investigation will eventually come up, and theoretically, you would use the investigation as evidence in your case to push your side of the story, right? That's where that comes in, and that's where that's relevant. So, irrespective of whether an employee sues or not, it's still always helpful to have a proper investigation done, because if you can show that it was properly done, you can still mitigate the damages, right? So, case in point, If an employee claims discrimination, the employer investigates and deals with it promptly, appropriately, and so forth. Then the impact of the discrimination will be lessened because the employer would have done something to address it. For example, terminating the employee who caused the discrimination. That's better than doing nothing. And then the employee will have less to show for because it will be clear that the employer did, in fact, do something about it and looked into it, right? And did what they could to keep a healthy workplace and safe workplace. So certainly it's always important to address things quickly. And when you do have an investigation, even if the employee sues and claims that the investigation was improper, well, you'll be able to show the opposite. Is it true that there's a 2 year limit on reporting? Not necessarily on reporting. There's a 2 year limit on cases. Well, not all cases, mind you, but generally speaking, for civil cases, there is a 2 year limitation period. So, for example, if there is a dismissal case that comes up, there's a 2 year window. And if part of that case involves an investigation, then theoretically the employee would have 2 years to bring the case forward. And if they don't do it, they may not be able to down the road. Keyword is may because there are exceptions. For example, dealing with an employee who has an illness that prevents them from doing something. That's one example. And there are other examples too. But generally speaking, absent any uh, sort of information to the contrary, it's usually 2 years. But again, mileage may vary because there are some statutes in Ontario that provide less than 2 years. For example, the Human Rights Code has a 1 year limitation period. So be careful with that. It's there's no one answer, but yes, 2 years, sort of generally. Let's see here. Oh, we're actually just about towards the end. Charlie, do you want to pick the last one or two questions that we should answer? Because I see we're nearing the end.
This one's actually very good. How does an employer protect themselves from false allegations or legal evidence or legal action? Specifically, if the employee has evidence and is providing false, has no evidence and is providing false statements.
So, well, again, that goes back to the investigation. So if an investigation finds that there was false evidence given, false statements, and so forth, well, for one, that's going to give a lot of sort of credibility to the employer because, well, they investigated and they found nothing. Also, at that point, you have to wonder as the employer, if an employee is making up a fake investigation or fake allegations, you might have to discipline that employee.
Sorry, I think Phil has frozen. I'll pick up where he's left off there. Building up what he was saying is that essentially, if you've got an employee raising false allegations, well, that's a problem in the workplace as well. As the employer, you need to make sure that the workplace is safe and free of any sort of harassment, discrimination, including false claims being launched against people. So the best way to do that is to conduct a proper investigation, go through all the evidence, and if there is no evidence to support these false allegations, that's something to put forward as well. And the best way to protect yourself is to conduct the investigation in an unbiased way. And if it's false statements or false, or there's no evidence, then that's something to put forward as well. Hey, Phil, I think you froze a little bit there. You're back with us now, I see. I want to thank everybody for attending today and thank you for the questions you submitted. Sorry we couldn't get to all of them. But if you do have any questions and you do have an active matter, please feel free to book a consultation with us. Our contact information is right there, and we would be more than happy to speak with anybody.
Thank you, everyone. And again, for any questions we didn't answer, feel free to shoot either of us an email. You have our info right there. And we'll see you all again next week for another presentation. Thank you, everyone, again, and have an amazing day and rest of your week.
Bye, everyone. Good afternoon.